Hello, scholars. This is Garrett Kepping, and today we are going to be discussing the levels of police interaction. What are the levels of evidence that police must satisfy in order to arrest or detain people? And then we're going to talk about the protections under the Fourth Amendment Search and Seizure Clause. So that'll be our discussion today. As always, these lecture notes are on the Synergy page, and let's begin looking at those. So again, today we're covering police interaction, search and seizure. They're both, as with any legal standard, one of the big things to always remember here is what is the standard? What is the burden that the police need to satisfy to be able to make an arrest, to be able to gather evidence, right? That's the thing. Now, as we get into this area of criminal law, often students ask me questions that are alarmingly specific about criminal rights and criminal prosecution. So to that end, what I would like to do is issue this disclaimer. I am not an attorney. This discussion is for the purpose of explaining general constitutional principles only. Do not rely on this material in determining what to do if you are involved personally in a criminal investigation. You should contact an attorney if you have a question about your legal rights in any specific case. So with that out of the way, again, let's talk about some general legal principles. We're going to start with levels of police interaction. The lowest level, or the easiest level for the police, is approach, where essentially the police just say hi. Right. Maybe it's a school resource officer who says hi in the hallway. Maybe you're walking down the street and a police officer comes up and says howdy, and starts a conversation about, how things are going for you today. The police do not need any justification for doing so. They can approach you just because they want to. So they don't need reasonable suspicion. They don't need probable cause. And as part of that, they can ask you if they can search your bag, if they can search your suitcase, if they can search you. Now, remember, during these exchanges, you have no obligation to tell them anything. Under the Fifth Amendment, you don't have to answer questions unless they have reasonable suspicion that you've committed a crime, as well as unless they have some sort of evidence or a warrant, they cannot they cannot require a search. So you can say, you can refuse to talk to them and you can refuse any search. Now, the next level of interaction is what we call a Terry stop. And it comes from a 1968 case called Terry v. Ohio. And the way this works is if there is unusual conduct that would make a reasonable person conclude the criminal activity is afoot, they can detain you. The length of detention has to be around 20 minutes. So any more than that, and this is no longer a Terry stop, it's probably an arrest. But again, if you are wondering if you're being detained, if an officer is detaining you, you can always ask, is this a Terry stop or is this an arrest? The requirement for the Terry stop is simply some sort of reasonable suspicion of unusual conduct that has the officer conclude that there is a crime afoot. So if you are acting strangely in public, if you are loitering, if you are simply in a high crime neighborhood, those would all be reasons for why they could detain you, temporarily stop you for a period of time. Now, if during this Terry stop, they have reasonable suspicion that you're armed or dangerous, they can also pat you down, where they pat down the outside of your clothing, attempting to feel the outline of a weapon. So the idea is that this pat down or this frisk is just a means of guaranteeing their own protection. Now, the combination of a Terry stop and this ability to pat people down leads to what some people call stop and frisk, where in some cities, specifically New York City, there was a police practice of going into high crime neighborhoods and basically just stopping every young man they found and patting them down. That, of course, generated significant resentment, but the policy came to be known as stop and frisk. So if you ever hear of someone complaining about stop and frisk, that's what it's based legally on Terry versus Ohio. Now, the an example of sort of this is this interesting case called the Wardlow case, Illinois v. Wardlow. So in this case, this guy was carrying a bag. He's in an area where there's a lot of drug trafficking. He sees the police and he starts running. Well, the police catch up to him. They stop him. They detain him. They're concerned he's got a weapon. They pat him down, and the reason for doing that is there was in areas where there's a lot of narcotics transactions, there also tends to be a lot of weapons. So they patted him down because of that. Sure enough, he had a gun. He was arrested for the gun. Now the question is that a legal search? There was, no explicit evidence of a gun, but he just ran from the police in this high crime neighborhood. In a 5-4 decision, the police, the Supreme Court ruled that the Wardlow's rights were not violated, and that stop was consistent with a Terry stop. So that is sort of an example, an application of the Terry stop standard. Now, the most serious of detentions, of course, is an arrest, where you are taken into custody by the police. This requires probable cause. So, probable cause is a fairly simple standard, and it basically said, would a reasonable person believe you probably committed a crime? So, examples could be, are you near a crime scene and you are running from it? Right. Well, that looks awfully suspicious. Are you hanging out with somebody who, let's say, is a known drug dealer in an area where there's a lot of drug dealing? Well, then the police will likely they could arrest you. If you lie to the police, they can arrest you for that. The police can even arrest you for even a minor traffic violation. So they could arrest you for speeding if they wanted to. Usually they won't, but they could. So these are all examples of probable cause that would then satisfy the arrest requirement. The police would take you into custody. So those are the 3 levels of police interaction: basically approach, Terry stop, and arrest. If you ever wonder if you are being arrested or if you are under a Terry stop, you can always ask. Is this, am I being detained under a Terry stop? Am I being arrested? And that obviously then is going to clarify the situation. Remember, you don't need to answer questions. Well, we'll talk about the Fifth Amendment later. So let's now move to the Fourth Amendment. So the Fourth Amendment basically says the right of the people to be secure in their persons, houses, papers, and effects. So that covers a lot of things. Against unreasonable search and seizures shall not be violated. So again, one of the big questions you have here legally is obviously, what is a unreasonable search and seizure and what is a reasonable one? It then goes on to say, warrant shall not be issued but upon probable cause. So it says exactly what a probable cause, what the necessary requirement for a warrant is, supported by oath or affirmation. So basically, the police have to swear as to some sort of facts to determine probable cause. And the warrant's got to describe the place to be searched and the persons or things to be seized. So the warrant cannot just be this bland statement saying we're going to search everything that has any association with the suspect. It's got to be defined as to what can be searched and where. So what does the reasonableness clause mean? Well, one of the areas that we look at is the question of when we look at reasonable is what we call expectation of privacy. Do the police have, or do you as a citizen have an expectation of privacy? So if I'm walking down the road and I commit a crime, obviously in public, I don't want to throw a rock at a car. I can't say, oh, when the police saw me do it, they were violating my privacy because I was in public. Same thing in the school. If you're at Lake Oswego High School and you commit a crime, your expectation of privacy there is non-existent. So you can't argue that when that evidence was gathered, let's say, we have cameras now in the school. Let's say you commit some sort of crime, the camera sees you. You can't claim that your Fourth Amendment rights were violated because you had no expectation of privacy. However, let's say you're in your home, right? The area that has the highest expectation of privacy would be your home. And your car, a little bit less, so everything's sort of a gradation. The garage attached to your house also probably has a pretty high expectation of privacy. But let's say there's a barn that's in the, in the backfield of your property, maybe that has less of an expectation of privacy. So this idea of sort of expectation of privacy sort of varying based upon context is a fairly important idea. One of the sort of interesting illustrations of this is actually garbage cans. The courts have held that a garbage can at the out on the curb has a low expectation of privacy, and that maybe the police can search that without a warrant. Whereas a garbage can, let's say, like I keep my garbage can behind my fence. So I would say, well, that garbage can has a greater expectation of privacy because it's behind my fence. Whereas I also have a garbage can that's in my kitchen. Now, that garbage can would have a very high expectation of privacy, and the police would certainly need a warrant to search that garbage can, but not necessarily the garbage can that I put out for the garbage collector. Now, one of the sort of interesting cases that I like is Kyllo v. United States to sort of illustrate this, because in Kyllo v. United States, the question was, do the police need a warrant to use a heat-sensitive camera to see if you're growing marijuana inside your house? Now, remember, the idea here is the police aren't actually entering your house, right? In the Kyllo case, the police were actually sitting on a sidewalk, and they were using these heat-sensitive cameras to see if somebody was growing marijuana. Back then, it was illegal in Oregon to grow marijuana. Secondarily, when you grow marijuana, you're often using um, these halogen lights that are they put out a lot of heat. And so the police cleverly realized that with these sensitive cameras, they could look into someone's home without actually entering the home. The question was, is that a search? Now, again, the police aren't entering the home, but the police can look inside your home using these devices and sort of see what you're doing, right? They could see whether you're watching TV or whether you're cooking dinner. And for that reason, the court said that no, that's a search, right? This comes from this idea that you have a substantial expectation of privacy inside your home. So even though the police weren't entering your house in the Kyllo case, the very fact that they were sort of intruding into the privacy of your home meant that the police couldn't do it, that was a violation of the Fourth Amendment. So in the Kyllo case, what the police should have done is they should have gotten a warrant. Now, warrants have to be issued by judges. Most municipalities have a judge on call 24/7. So if the police need a warrant, sort of an emergency warrant for something happening, they can get one fairly quickly. But even then, there are a number of exceptions to the warrant requirement. So yes, the Fourth Amendment is quite clear that the police need a warrant to search your home, but the courts over time have made a number of exceptions to the warrant requirement. The first one is consent. If you agree to be searched, then you don't later get to claim that the police violated your Fourth Amendment rights. You agreed for the police to search your house or your car or your backpack. And so then if the police find something, that's on you because you agreed to let them search. Now, refusal to allow someone to search does not create justification. So sometimes, and remember, police officers aren't really required to accurately describe to you what your legal rights are. That's not really their job. That's my job. So the police can sometimes say things like, well, if you don't let me search your bag, then it makes you look guilty, which then gives me probable cause, which then means I can search your bag. No, it does not work that way. The refusal to consent to a search cannot and will not ever create the justification for the search. You absolutely have a right to refuse to consent to a search. Now, sometimes the police can still be justified. Maybe they'll get a warrant. Maybe there'll be some other exception they can use, but you never are forced to consent to a search. Next is search incidental to arrest. So if the police arrest you, they need to make sure that you're not carrying a weapon or any contraband or anything like that. And so they will search you and your area of control, right? So basically, if I were arrested, here in my office, they would basically they could search my desk. They can maybe search, basically wingspan, area I can reach, but that'd be about it. Search incident to arrest. If they find if they find like a diary or something on me, they could look in the diary. The one interesting wrinkle here is cell phones. If they find a cell phone on me, they cannot search that cell phone without first getting a warrant for the cell phone. And we'll talk about that case called Riley v. California. So search incidental arrest does have limits. The next is what we call exigent circumstance or exigency. Sometimes people also call it the hot pursuit option. But the basic idea here is if there's some emergency, so the police see you commit a crime, they chase you, you run into your house, the police don't need to get a warrant at that point. They can run in and arrest you. Doesn't mean they could then search the whole of your house, but it does mean they could certainly go in and arrest you. And so this would also be some sort of emergency situation. In Lake Oswego, there was a case years ago where there was a burglar alarm that was going off, and so the police entered the house looking for the burglar. Right, that was the exigency. You needed to get in the house to find the burglar that the burglar alarm was apparently concerned about or indicating. They searched the house. They didn't find any burglars, but they did find, I think it was on a dining room table, a small shoebox. They open the shoebox and they find marijuana inside, and they then arrest the owner of the house because of marijuana possession back when that was illegal. Now, the challenge here is that when it comes to an exigent circumstance search, it's got to be related to the exigency. And so, as you may imagine, that evidence actually was excluded because the police were there looking for a burglar. Obviously, the burglar wasn't in the shoebox, and so that evidence was excluded. So, let's say, for instance, the police are walking by a house. They see a trail of what they think is blood leading to the front door. They're concerned someone is injured. They enter the home, realize it's just a bottle of leaking ketchup. They would then have to terminate the search or the entrance at that point. They couldn't keep searching or looking for evidence. The search would have to terminate as soon as they realized there wasn't actually a crime. But those are exigency. Loss of evidence. So sometimes if maybe there's a violent crime, and they want to make sure that there's no DNA evidence under somebody's fingernails. Maybe they want to take a blood test to measure, say, blood alcohol level or the presence of intoxicants in the bloodstream. The police could then do that without getting a warrant because they need to gather that evidence. If the police come to, say, a party of underage high school students, and they knock on the door, and all of a sudden students are jumping out of the windows and running away, well, then their evidence is running away, so they could enter the house to stop that evidence from running away. Motor vehicles do have a lesser expectation of privacy. If there is probable cause that there is in the trunk of a car, the glove compartment of the car, evidence, then they can search it. But it still needs to be probable cause. It also there's got to be some reference as to why they believed it. So in other words, let's say they pulled somebody over who had the odor of alcohol on or about their person, and there was, I don't know, they reeked of alcohol and they're slurring their speech. The police might be able to search the car looking for evidence of alcohol. But let's say they pulled somebody over for speeding. Okay? Well, there's nothing in a car that's going to show evidence of speeding. So that's not going to be a justified search. So the probable cause is usually going to have to be some sort of evidence. So one of the classics is, police pull a car over and somebody's in the trunk saying, help me. And well, then obviously that's probable cause. The police could look in the car. We already talked about Terry stops. Lastly is plain view. So if the police inadvertently see contraband or evidence, then they can seize it. So if the police are walking by and you've decided to put a meth lab in the bay window in the front of your house, and the police see the meth lab, well, then they can go ahead and enter the house and seize the evidence and arrest you. So if there is evidence in plain view, the police can go ahead and act upon that evidence. So let's say somebody's having a high school, a party where underage drinking has occurred. There's a noise complaint. The police walk up to the front door, and it's got one of those nice big glass windows, and they look through it, and clearly there's underage people drinking alcohol. Well, then that'd be plain view, and the police could go ahead and enter the house without having to get a warrant. So those are the exceptions to the warrant requirement. Most searches that the police do anymore actually aren't warrant searches. So there's a lot of exceptions. There's so many exceptions that most searches anymore fall under one of these exceptions, and that warrant searches are less common. Now, Riley versus California is the case I talked to you about. When it comes to the Fourth Amendment and technology, there's been a lot of interesting cases, and the court has generally found, recently at least, that technology does have some privacy protections. So, for instance, in Riley, this guy was pulled over. They find a gun, they arrest him, and on him is a cell phone. And they search the cell phone. And the question is that a violation of the Fourth Amendment? After all, it was the cell phone was gathered as part of an arrest. And so usually you can search the product of that arrest. But what the Supreme Court said is that the issue with the cell phone is there's so much information on there. I mean, basically our whole lives are on there. And so as a result of that, the court said that no, you really, even if you got a cell phone as part of an arrest, you really need a whole nother warrant to be able to search the contents of that cell phone. US v. Jones, this is another example of technology. In this case, the police basically, without getting a warrant, put a GPS tracking device on a car to sort of basically track the movements of this narcotics suspect. Court said no, in that case, you still need a warrant because you're basically attaching a device, and the phrase that was used in this case is as if the police were attaching a tiny constable. So again, here's technology and technology's ability to intrude, and the courts are wary of that technology be limited in its ability to intrude upon us against police searches. Now, these are some scenarios that some law school students created. You can spend your own time looking at them if you'd like. But basically, the idea is, let's say you have a suspect, we'll call him Pig, and he's standing on a corner in a downtown street. They stop and search him. They find drugs in his pockets. Would that be a legit search? And the answer is no. There's no probable cause. There's no mention of them worried about a weapon, so they can't. It's not a Terry stop, and they couldn't use it as a pat down since they actually reached into his pocket. So for that reason, no, they'd need probable cause, and just being a sort of a known bad guy standing on a corner doesn't satisfy it. Now, in another case, let's say they receive a tip from a reliable informant that Earl has counterfeit money in his office. Acting on this information, they get a warrant. However, instead of counterfeit money, the police find illegal drugs. Would that be legal? Yes, it would be. They had credible information. They got a warrant. Even if they were looking for counterfeit money and they end up finding drugs, that's still fine because the search was legal. Okay, so the police got there, even if they're looking for A and they find B, the search is legal, you can still use it, so long as you had a good warrant. Again, here are two more scenarios. Officers witness a suspect breaking a car window, stealing the airbag. Suspect runs down the street, following it. Perp then runs into a house and refuses to admit the officers. Can they get in there? Well, the answer is, of course, they do not need a warrant since it's a hot pursuit. So we talked about exigency. So that would allow them to search without a warrant. How about two officers obtain a warrant to search a house and a detached garage? So the warrant says house and detached garage. They don't find the contraband they're looking for, but there's an automobile parked in the driveway. They search the bag for betting slips, which is evidence of illegal gambling. What is the step? Could those betting slips be admitted in court? And they would not be used as evidence because the warrant did not include the car. So if the police don't think to include, some other location in a warrant, that evidence is not going to be allowed. So that's our discussion of search and seizure and Fourth Amendment. I hope you have enjoyed it. Have yourselves a lovely rest of your day.